SJC-11264, Commonwealth versus Tavares.
Ms. Pumphrey, good morning.
Good morning. May it please the court. I'm Janet Pumphrey for Paulo Tavares. The motion to suppress. The misstep number one, the initial stop. Officer Schaff testified, as I got to the vehicle, I realized the party in the back seat was not the party we were looking for.
Now, the defendant was not the driver, right?
But it was not the driver.
Okay. And that's really like the sort of the linchpin of the Commonwealth's argument about why it is that what you're arguing doesn't make any sense, right?
I'm not so sure.
Okay. Go ahead.
You would say as to the impoundment, it certainly is
Yeah.
their argument, but as to the Commonwealth versus Torres issue
Yeah.
and how long it needed to be before they were let go, once there was a recognition that the
exactly.
individual with the outstanding warrant wasn't in the car,
Exactly.
that there's a right to raise the issue, expectation of privacy as to that threshold issue.
Exactly. I'm talking the initial stop should have ended it right there because, he said, as I got to the vehicle, he recognized that he had no reason to stop them.
So what about, I think, let me sort of take Judge Healy's point if I'm getting it right as to that issue, because that's a huge issue.
It's a huge issue.
Because everything else, you might be okay. I know you say it isn't, and maybe it isn't,
Yeah,
but it
yeah.
might be okay. But he basically says that it was such a minimal intrusion that just continuing the conversation with these people that the police officer knew didn't really require a constitutional justification for that very minimal intrusion. I'm not sure he put it quite that way, but that's his point, isn't it?
I think he put it exactly that way. Schaff testified that he knew exactly who these guys were. They were calling each other by name. He knew who they were, and he made.
You know the driver, right?
I thought he knew all three. He asked names. He asked for a license and registration. He asked for names, but he also testified he knew them.
So what's the response to Judge Healy's point?
That it's not that it is minimal. It's not minimal. This is basically in my reply brief I say look at the Terry stop cases, look at the stop and frisk cases. It should have stopped at this very first point, no license or registration. Getting on to license and registration, and you did get my reply brief. It was very recently filed.
Before you leave on that, you're not challenging the appropriateness of the initial stop, are you?
I am. Well, not the initial stop. The initial stop because he thought he recognized this guy who had a warrant. That's fine. But as he walked to the car, he realized he was wrong, and he should have waved them on.
You're saying the stop basically should have been a never mind, I made a mistake, and then it should
Totally,
have ended.
totally, and no getting to no getting to.
But
the
you're
second
not
step.
challenging then if you are right, and if the stop was unconstitutionally prolonged, you're not challenging the admission of the gun that was thrown from the car and then retrieved by them.
No, I'm challenging the car itself and everything that's related to the car.
So this would not affect the admissibility of the gun and the
Although,
and the
actually,
ballistics.
I take that back because I don't think that the gun would have been, there would have been no testimony the gun was thrown out of the car, and other than the fact that the car was stopped because they saw police officers after them, and then they went back and found the gun.
But didn't that come from his conversations with
It did not.
with the Grinion?
It did not.
I'm sorry, I thought Grinion, I thought he had told Grinion.
Oh, it came
that
from
he-
Grinion, yes, it came from Grinion, but
Right.
not from anyone else.
Are you claiming that if you are right, then even Grinion's testimony gets suppressed?
I don't think Grinion's testimony should be suppressed for these reasons, but I do think that Grinion should be cross-examined further, and I'll get to that.
Can I ask a question about the stop? At the time of the stop, were they investigating, looking for a car like this?
No, that didn't come until much,
I understand the answer to that question because I may have the
Yeah.
timing wrong then. I thought the police officer says, oh, they're not on the rental agreement, so they can't drive, you've got a Supreme Court case to address whether that's a legitimate concern. And then he's going to leave the car there, and then he says, wait a minute, it matches the description.
That's exactly right. It comes not that long afterwards, but after he's told the guys, you can go now. He does realize that it should be kept. Getting on to.
Can I slow you down just a little bit?
Sure.
Because I'm trying to, the timing. So, again, they see the wrong guy, it's not the guy. But, you know, the police can talk to people, right? And they know these guys. So I take it the first hello is voluntary, right? Does it become a stop when they ask for the license? I'm just trying to, I want to do the movie.
Steps, yeah.
Steps, because it may matter, may not, but, so they're allowed to say hello, right?
They are allowed to say hello.
Are
Well,
they not allowed to ask for the license?
I don't think they're allowed to ask for the license and
Is that when it
registration.
becomes a stop?
It really becomes a stop once he recognizes that,
But
that he's,
it's a permissible stop, though.
it's a permissible stop, but he should have let them go.
I get it, but. he
Assuming
also-
exactly when he recognized, but he says, as I got to the vehicle, so I assume that's before he even said a word to them, as I got to the vehicle.
So doing this one frame at a time, is there testimony from the police officer before he asked for his license and registration about damage to the car? Is there an
No.
observation made, any
No.
questioning at that, at trial?
No.
How do they get to the rental car? When does that come up?
It comes up with the license and registration.
So he asks for the license, and they give him the registration, then it's be clear it's a rental car.
That's right.
Okay, and then they get into trouble here, right? Because then they run smack into Justice Lank's case about what they can do with rental cars, right?
Well, I'm correct, but
But yeah, go ahead. I want to run the movie a little bit, because I want
Okay.
to try to understand how many search and seizure violations you're talking about here.
I'm talking about at least 3, if not 4. I think
Go through them, your position is number one's enough.
number 1's enough, absolutely. Number 1's enough, number 2's enough, number 3's enough. As soon as he recognizes that it could possibly be this car, then I think that he's justified.
The car was stopped with the blue lights? How was the car pulled over?
It was pulled over with blue lights, I think, yeah, because that's when they threw the gun out.
Okay, so it was a
It was a stop.
stop, okay.
I'll double check that, but it was a stop. I mean, I don't know why else they
Anything
would
in
have
the briefs
stopped.
about how the stop occurred, but I did,
Yeah.
Grinion certainly says, the defendant said that they had noticed. I wasn't sure whether they had just observed a police car, whether it was a marked police car.
Yeah.
But, okay.
Okay, so now let's get to sort of, the Commonwealth, I think, recognizes they may have some problems, they may not, but then they're saying he has no expectation of privacy in the car. So he's not the driver, he's a passenger. How does now he get, is this all fruit of the poisonous tree?
Exactly.
But, so tell me some cases where you've got constitutional violations, but then you have no right to the car. Give me some cases where we do that analysis.
I want to make sure that you got my reply brief because there are cases
Well,
in
I'm
it.
starting to realize I probably didn't know, when did you send your reply brief?
Just this week. I electronically filed it, I think, on Monday. Am I right, Maura? Monday, and then paper copies you would have gotten on Wednesday.
Yeah, I have your reply brief, but I
Okay.
think I
Well, look
probably
at the-
synced my computer and not
Yeah.
realized it was there, but that's okay.
There's
Sorry.
a wonderful case from Ohio that was pretty much on point.
Okay, but how about Massachusetts? We like Massachusetts.
Massachusetts, I think I've given you a couple of cases, but I can't cite them off the top of my head.
Okay, so there are cases we can turn to where even if you don't have an expectation of privacy in the object, I'm not talking about drugs, but we found that even when you don't have an expectation of privacy, it's fruit of the poisonous tree and it's all out the window.
That's exactly right, and it's really the Terry stop cases that I'm talking about, because this is not a possessory case where there are drugs or a gun in the car. That's just not this. But they wouldn't have gotten to the car if
The
had they
Terry
not.
stop cases, all you have an expectation of privacy. So
Well, in
this is-
yourself,
Right, so are those the best cases we've got for this?
those are the best cases because
Have any cases like Is the Ohio case like this one where?
The Ohio case is much like this one.
Okay, all right.
Does
But
does it matter? Did you cite, I don't know if you cited Commonwealth versus Crowley-Chester. The issue wasn't addressed, but we did find that a passenger in a car had standing, we gave a standing to somebody who was a passenger in a car regarding the impoundment of the car.
Okay, okay.
But the issue wasn't raised in the case. We
Okay.
just- the
I
rescript.
don't think I did raise that case, but I'll look at it when I get back to the office.
It's 476 Mass 1030, but it's a rescript, 2017. So does it matter that it was the defendant who was authorized by the renter to use her car?
No. And that gets me to the next point, which is the request for license and registration. The motion judge's finding on this point was clearly erroneous, as the Commonwealth rests its case on this. And the motion judge found, and the words are important here, the motion judge found that the officer's request for the operator's driver's license might have ended this encounter in very short notice. So the motion judge recognizes that, it should have been over here, except that the motion judge found that there was conflicting evidence as to who the renter was, who the car was rented to, whether it was Tavares, whether it was the girlfriend, and there just wasn't conflicting evidence. Schaff testified at the suppression hearing. He asked whose vehicle it was. He was informed it was a rental. He was asked from whom did he obtain the information it was a rental. He said from Mr. Tavares. He was asked, and the person that you saw in the front seat and passenger side, he confirmed, yes, Mr. Tavares informed me that the car was a rental. It was his girlfriend who had rented the car. It's absolutely crystal clear. There's no conflicting evidence as to who rented the car.
And if it is, isn't your position that, fine, that's a Commonwealth versus Campbell, it's, that might be some issue for enterprise,
Oh, exactly, for
But,
enterprise, but it's not
but-
an issue here.
and you say Commonwealth versus Campbell addresses that issue.
I'll find out, but I don't think I cited Commonwealth versus Campbell, and that kind of gets to the third point, and not just the license and registration here. So there's no conflicting evidence that would, that's basically what the motion judge rests his hat on, that the driver's operator's license, the encounter might have stopped here, but for this conflicting evidence, and there was no conflicting evidence.
Wouldn't it have been enough to just say, well, it was a registration? I mean, I don't know if Campbell was out at that point. Did the police?
It was 2016. And
Yeah,
you-
this is quite a while ago.
And you did cite it
I did, okay, good.
on page
Sorry,
24.
is Campbell out before or not?
No, Campbell was 2016, and this stop occurred well before that.
Oh, this is well before that.
When police thought they could do this sort of thing.
Pardon me?
When police thought they could do this sort of thing.
They thought that, especially in Brockton. I think so.
You
Sorry,
know
say
what?
that again?
Especially in brockton, she said. But, I think this goes to Justice Kafka's questions. It's just that something feels, when you're talking about observing damage to a car, that the police did not, went beyond the reason for the stop. No doubt. They exceeded the reason for the stop.
Because they don't know the damage yet, they don't know that this car, at this point,
Yeah, and Judge Healy recognizes that, and that is a serious concern. But what we have going on is the police officer is going to have the renter come pick up the car. It's not the defendant's car. It's not even the defendant's girlfriend's car, it's Enterprise's car. And then he says, this looks like the same car that might have been in that murder. And the issue is the damage and the identification of the car and tying it to the observations from the porch of the witness.
from the other person.
It just feels like, I don't think the Commonwealth cites any case to address this. It just seems this is beyond the fruit of the poisonous tree at this point. Maybe it isn't.
Yeah, yeah.
But that's what I think Justice Kafka was getting at. It feels like it's beyond the fruit of the poisonous tree.
What do you mean beyond?
That some attenuation, which doesn't apply to these facts,
Yeah,
doctrine,
yeah.
would apply. It's so distinct from the minimal constitutional intrusion that clearly was one.
Exactly.
But I'm getting confused, though, and I don't disagree with anything just slowly just said, but, so again, he's not the driver.
He's in the front seat.
He's in the front seat. They ask them all to leave the car. Do they offer the girlfriend the opportunity, someone to call a girlfriend? Or you're telling me, I take it that the impoundment was improper too, right? Is that right?
Exactly.
Okay. But again, he has no expectation of privacy in the car. But we turn to this Ohio case and says, doesn't matter. Because they wouldn't have the car
They wouldn't have
without.
the car, absolutely, were it not for this stop.
Now, you'd think this would have come up in Massachusetts somewhere besides this.
I couldn't find an exact case on point, but the Ohio case is. With respect to whether it was a minimal stop or not, I gave you the stop and frisk cases from New York, which cite all kinds of studies that say that this is 3 black men driving around in a car. It was way beyond the pale, in my opinion.
But we have no reason to believe this stop was based on a implicit bias or racial.
Not the initial stop, but the continuing to question them and make the small talk as though he were looking for a crime, which he did not find.
Or maybe he's looking for the Impala.
Looking for the
Impala.
Malibu, you mean.
Yeah, he's looking for the car, maybe. He's
but he at this point he wasn't looking for the car. Happens later.
maybe.
I don't think it's an impoundment issue. They clearly can't impound the car because they take the car for investigatory purposes.
Yeah.
The issue is whether or not, at that point in time, he needs a warrant and they have to put a police officer there by the car so
Yeah,
it's not
exactly.
damaged.
Yeah.
And they need to get a warrant.
And they need to do it right.
Or whether, somehow, even though Commonwealth versus Mata doesn't apply, somehow they don't need to have a warrant here. But it's not, impoundment's off the table because even the Commonwealth is saying this is not administrative, this is investigatory.
Totally.
They don't, it's not even the right color of this car, right?
It's not even the right color of the car. Exactly. It's not a Malibu Max. It's just a Malibu sedan.
There are a lot of Malibus out there, right?
I guess. Yeah.
And they're looking for a gold Malibu, and this is a gray, I can't remember, the color is different.
This is a gray Malibu, and they're looking for a gold one. So, when Officer Shaft would have realized that perhaps this is the car, it's not until he tells the guys to walk away.
And do we know how he knows these gentlemen?
He knows them. Brockton's a small place. I wouldn't say.
Not that small.
I wouldn't say such disparaging things about the Brockton Police Department, except that I know of another case where they did exactly the same thing. They took a car illegally and then brought the eyewitness in to say, and they say, they have it wrapped in tape, and they say, here's the car, and he says, yes. And that's just, it's not good police behavior, and it really should be stopped.
And these gentlemen don't meet do we know anything about the shooters? I can't remember do we know, is there a description of the shooters from the day before or
I don't know, there's not.
No description, it's just the car.
It's just the car at this point, yeah, absolutely.
So Ortega testified at trial, correct?
Ortega testified at trial and Grinion testified at trial.
Okay, and even if you prevail in getting a new trial, they can still testify at the next trial.
They could, absolutely.
And the gun that was found, which appears to be the gun that he told Grinion about, which Grinion reobtained and was the gun used in the shooting, that comes in.
Maybe. Which gets to my last point, which is the prior bad acts.
I'm sorry, but before you get to that, I completely do not understand your Section 99 fruit of the poisonous tree argument.
Okay.
And here's why. The informant can testify to the conversation. I mean, the fact that did the trial attorney actually have the transcript?
The trial attorney had the transcript.
And used it?
Didn't use it.
Okay, so that might be, not for today, that might be an ineffective assistance counsel.
Well, that's my second and third arguments.
Not on that ground.
Not on this point, but
Not on that ground.
But and I'm the third appellate attorney at least, and
My fault, I threw 3 things at you once, I apologize. On the wiretap on the fruit of the poisonous tree. And Judge Healy says, well, there's no fruit. But the more important point is everything that is in the tape that they're testifying. I understand maybe there'd be some impeachment. I don't understand the fruit of the poisonous tree from the wiretap at all.
From the wiretap. No, this is fruit of the poisonous tree from the car. Oh, fruit of the poisonous tree from the wiretap.
You're saying
on the
that
second argument,
anything that derives from the wiretap was ineffective not to move to suppress it. Nothing derives from the wiretap because the informant was able to testify.
The informant was definitely able to testify, but my point on that issue is that perhaps the informant could have been cross-examined on the wire. Perhaps he was coached. We talked about that when I was here for the 211-3. Perhaps the informant was coached with the wiretap, and he shouldn't have been coached. It should have been available for appellate counsel, and it just wasn't.
Well, but it was available for trial time, and so you can't make an argument of ineffectiveness there. I mean, there's no Woodbine argument like you raised in your brief. There's no ineffectiveness because we don't know anything about what the attorney had in that transcript.
But again, it's catch-22 that we wish we had the transcript.
Well, I think we sort of indicated that in a footnote, that it was mystifying why you don't.
Why there was no transcript, absolutely.
I just want to make sure I understand. Grinion, how does Grinion get connected in here? It has nothing to do with the stop? Is Grinion's testimony totally on its own?
Grinion's testimony is totally on its own. Grinion was, his credibility was the crux of the case, which is why cross-examining him is so important.
So there's Grinion's stuff is not contaminated by this?
No.
Ortega is in the car. Why is Ortega's stuff, why is his testimony?
Ortega testified also, and I think he can testify as long as it's not about the car.
Okay. So
And
Ortega,
then the defendant, okay, I'm sorry.
yeah, so they get, how would they know about Ortega but without the stop?
Good question as to whether Grinion led them to Ortega. I'll have to check and see.
Okay, all right, okay.
Okay, thank you.
Okay, thank you. Ms. Yashulis.
Good morning, Your Honors. May it please the Court, Laurie Schulz for the Commonwealth for the Plymouth District. Your Honors, could I please address the Court first and foremost a characterization of the Brockton Police Department? I would suggest that that is not proper and appropriate here.
I think you've got bigger problems than getting into that. Let's stick to the legal
Well,
issues.
and I'd also like to address the reply brief where it's raised for the first time in a reply brief that there was some sort of motivation for prolonging the stop because of the race of the parties. I've reviewed the
Again,
motion to suppress
we
transcript.
We got really difficult issues. Let's
Correct.
get to the substance for a second. How do you, I have real issues. I need understanding from you. I understand the original stop is legal.
Correct.
How do you?
So I'll explain to you how this,
And
so what
you should
happens
walk
is.
through step by step.
Step by
Because
step.
we're going to have a lot of
I
problems
refer
step
to
by
the
step.
cross-examination of, on the hearing testimony of Detective Schaff, his cross-examination, he says he approached the car and asked the driver for a license and registration immediately. So that's a common thing that we do in the cases that the,
But we commonly do it when we're doing a traffic
violation,
violation.
this
Or
is
we're
not.
pulling over someone for a warrant.
So what
If we're pulling someone over and we realize we got the wrong guy, don't we say, sorry, I got the wrong guy?
He did. And so he did say that. In his direct examination at hearing at page 9 and 10, he goes and says, I'm sorry, I thought you were somebody else. And so the defendant and the people in the car start calling Detective Schaff by his last name. And in fact, the defendant tells Grinion that we're joking with him. We don't think he has any evidence on us because we're joking with him. What happened when Detective Schaff said, "Oh, sorry guys, I pulled you over. It's the wrong. I thought someone else was in the back seat. My bad." The defendant and the occupants of the car started engaging him, calling by last name, and joking with him.
So how did that
It turns the investigation into a conversation, which Justice Kafka, I think you alluded to, the police are allowed to do. The defendant was never, no one was ever said, stay in the car. During the course of this conversation, it was learned that this was a rental car.
But why, I understand it may be, how does he get the right to ask for his license?
I'm not 100% sure that he asked for the license and registration. We don't know exactly how the conversation unfolded. We know they were joking around with each other and that they knew each other. And at some point, the defendant, and I agree with the counsel that, that the motion judge may have been confused in saying that there was conflicting information, but regardless of who the information came from, the defendant or someone else, during the course of their conversation, not an investigation, conversation, it's learned that the car's a rental and it was rented by the defendant's girlfriend. It's important here because there's no female in the car. Detective Schaff testifies.
Isn't it important, though, to know
It
how?
is.
No.
I'm sorry, go ahead.
That's okay. Isn't it important to know how it is that this information came out about the rental car? Isn't it important for us to know that? Because if it was
it may
based
not
on
be.
a police officer asking questions that he really had no business asking.
They're all joking with each other. They
Well,
know each other.
That's fine, but
And the defendant is joking with him, trying to distract him from the fact that he just threw a gun out. So the defendant's calling him by the last name, joking with him.
Understood.
They're in a playful conversation. In fact, the defendant, in reply, characterized it as a pleasant conversation.
understood. But then it turned into an investigation.
I think what happened was during the conversation, and this is in the hearing, I think at some point Detective Schaff says, whose car is this? Maybe he knows them and knows this isn't their car, and it comes out that it's a rental and that the defendant's girlfriend had rented it. And Detective Schaff testified, hey, I know Enterprise doesn't allow unauthorized drivers to rent their cars, and there's no female in the car. So it was reasonable for him to say, can I see the registration? And they hand him the rental agreement.
That we have Commonwealth versus Campbell, which is post-stop, but we have Commonwealth versus Campbell.
I'm not familiar with Campbell.
Well, I think the bottom line is that, that the rental car and not being on the rental agreement might be a concern for Enterprise, but it's not really constitutional justification to continue an investigation.
So I think it was brought out during the earlier argument that Campbell was decided in 2016, and here we have a stop in 2007. So I suggest to the court that maybe that wasn't, I know that wasn't the law at that time, and at that time Detective Schaff said, you know, I knew Enterprises through professional and personal experience that they're not authorized to have non-authorized drivers drive the car. And let's keep in mind here, the defendant's never detained. He was always free to go. It was the driver who was asked for his license and the registration. The defendant was never detained in the car. He could get out of that car at the moment and say, hi, see you guys, I gotta go somewhere, and leave.
But it's his girlfriend's car. Why would he leave it?
It's not his girlfriend's car, it's a rental car,
It was his girlfriend who authorized him to use it.
but the girlfriend authorized Hanson to use it,
But
who was the
Enterprise
driver.
decided. It doesn't matter what Enterprise thought. It doesn't matter what Enterprise
The
thought.
girlfriend said she authorized Hanson to drive the car, not the defendant. The defendant was unlicensed.
Who's Hanson?
Hanson was the driver.
Okay.
The defendant was a passenger, front seat passenger, and he
Still,
was
my
unlicensed.
question is still the same. Why would he leave his girlfriend's car?
Because he couldn't drive it anyway. And if they're as the Detective Schaff explained to them, you're not authorized to drive the car. I'm going to put it aside here. I'll take the keys. You can have your girlfriend come and get it. We're going to put it over to the side. And they were all free to leave. And they did leave. They walked away. No one was searched. The car wasn't searched. The car wasn't searched until after Enterprise had canceled the contract with his girlfriend, and they received consent the following day to search. Car was never searched. And that's the biggest picture here. What are we talking about the defendants trying to suppress? The outside of the car? The eyewitness could have, even if they left the car on the side of the road.
The defendant's argument is it's all fruit of the poisonous tree.
But what do we?
They're saying, I mean, I gotta go back and read. It's Justice Walker who made the fact findings.
Correct.
So I gotta read Justice Walker's fact finding, but I don't remember it being voluntary as opposed to a limited intrusion.
As far as asking for
He
what?
doesn't describe this as a voluntary encounter. He describes it as a minimally intrusive encounter.
Judge Walker
which is
does.
the concept I'm not familiar with, really, but.
The minimum intrusion, I think a lot of the case law talk about that when we're talking about the civil stops infraction cases. We're asking for a license and registration is usually the first step, and that's a minimal intrusion. When they talked about prolonged, holding someone for a prolonged point of time, if you look at all the cases that the defendant cites and that I actually did some research on, since the reply brief, if you look at those cases, they talk about prolonged after a license and registration, and they talk about they ask for a license and registration is kind of like a threshold inquiry, and that's why it's a minimal intrusion.
If you pull somebody over and you don't have, say it's for a broken taillight, but the motion judge doesn't credit that there was a broken taillight, then you don't get to the license and registration. The defendant's position here is that you don't get to the license
Well,
and registration.
And most respectfully, I think the defendant is just wrong in how she characterizes, or he characterizes this encounter. It's initially stopped for the person in the back.
All right, let's give you the benefit of the doubt on that. Then we still.
Then it becomes a conversation. They're all joking around. It changes from,
I got it. There's
it goes-
layers, I got it. There's layers of complexity. I'm giving you that, okay? We got a case that says you can't do it. So you gotta argue either, so we got Commonwealth Kimball, you can't do it. Wait, hold on. Okay, you have to go around Campbell. Okay, they can't ask for the license and registration because of the rental. So you need either a good faith exception to the exclusionary rule that we don't have, or you need inevitable discovery. Because you can't ask for the license and registration as a result of the rental.
most respectfully, Your Honor, if the way I read the hearing transcript, they're having this conversation, the investigation part's over, they're having a conversation, and it comes out that it's a rental. That's when he asks for a license and registration.
I know.
So at the time, Campbell's not out, and the officer's aware that
By the way,
he's not supposed to
can I just
ignore what he.
pin you down on that factual thing? Does Judge Walker actually do the order you're doing it in, or are you actually sort of surmising yourself? Because I don't, it seems to me logically that he would have asked for the license and the registration, and then it becomes clear that it is a rental car. But go ahead.
But Judge Walker, this might be a paraphrase in my brief, but he says he approaches on the driver's side, able to determine that the person in the back seat is not who he's looking for, and he knows the occupants, they know him, and they engage in small talk, and then he asks for the license. That's the way Judge Walker found the facts.
Why don't we
If
actually
you look at the
at the
hearing.
So Schaff's approach, Schaff positioned himself, he was able to determine the individual is not Correa. He knows, I'm reading the actual findings. Knew all three persons, I'm on addendum page 2. He knew all three persons in the Malibu and they, him. Engaging in small talk, asked for the driver's license. So
So if
he
we look
asked
at
for
the
the
hearing.
driver's license while small talk's fine with cops, but when they ask for your license, that's not
So-
small, that's not like, hey, I want to get to know you, is it? You know,
Right, but if we
"Hey,
look at the
I'm
actual
hanging out
hearing
with you
test-
on the streets, and I'd like to chit-chat about the neighborhood. He's asking for his license for a reason, right?
Well, if you look at the actual hearing testimony on pages 9
I'm
and 10.
interested in the fact-finding, because I got fact-finding here, right?
Correct. And you can credit that fact finding, but if it's uncontroverted, and if the hearing testimony is in controversy to that, I would look to the hearing testimony.
So you're saying that that is a clearly erroneous fact-finding?
I'd have to relook at everything together, but, that's what the judge found. I'm not sure if he had the hearing transcript when he found it. The denial was a couple months after the actual hearing, so I don't know if he was writing his factual findings from his notes or from the actual transcript. But the transcript says that after informing them that he thought they were somebody else, Detective Schaff engaged them in small talk. They called him by his last name. They had a brief conversation, and it's during this time that Schaff asks whose car it is, and he's informed by the defendant that it was a rental, and it was rented by his girlfriend. And we don't know whose car is this? Like I said earlier, he may have said, hey, whose car is this? It's a new car, I don't recognize this car. We don't know how they know each other, which is true. So it could be an innocuous, hey, this is a rental. Detective Schaff knows that there's no female in the car and asks to see who's authorized to drive the car. And if no one's authorized to drive the car,
Wait a minute. You just said that he knew there was no female in the car, and then he asked for the rental agreement. That can't be right, because he wouldn't have known that a female rented the car.
he was informed by the defendant that it was a rental and that his girlfriend had rented the car. And then he asked for the rental agreement to see if any of the persons in the car were listed as authorized drivers. That's a fair reading of Schaff's testimony on hearing pages 9 and 10.
You have any cases, your sister has pointed us to this Ohio case, where we have, say we don't agree with you, that we find this is fruit of the poisonous tree, but at the same time, he has no standing in the car. You have us cases that this, somehow it doesn't matter if you don't have, if you have no reasonable expectation in the car, but the reason they have the car and they're looking into it is because they violated the Constitution, what do we turn to say that's okay?
You know, I don't have any cases off the top of my head, but what I'd like to say is this was not a seizure in the constitutional sense, because a seizure would be, you know, under Watson, a seizure would be someone would not feel they were free to leave. And I would suggest that that is not the case here. When this conversation is happening and joking and back and forth.
I understand he's not seized, but you may have as many as 2 or 3 violations, Fourth Amendment violations, in the sense that the stop after once they figure out the guy's not the guy in the warrant, you may have, they didn't have the right to ask for the license, they didn't have a right to engage in this rental car conversation, and I'm trying to still have you win. So tell me how you win if that's the case.
So
okay?
there's an unpublished case, Your Honor, and I apologize I haven't had it in my brief because I discovered it this week after reply brief. It's Commonwealth v. Korea, Carrion, C-A-R-R-I-O-N. It's 92 Mass Appellate Court, 1123. It was a 2018 case. And in that case, there was an execution of a warrant.
92 Mass App Court what?
1123.
Okay.
It's a 2018 unpublished case. And in that case, there was a search warrant in a home. And after the warrant was done, conceivably the police had no longer reason to be in the apartment, but they engaged the girlfriend there in conversation. And what the appeals court said was that was okay. The engaging in conversation was okay, even though the purpose of serving the warrant had ended. It was okay because she spoke freely with the police officers. And I think the same thing could apply here. So I'm not entirely in agreement that it was a violation. This was a conversation.
I understand you disagree with that, and you may be right that it's all voluntary, but I'm not sure. But go ahead.
And so I would look to that case, at least, to say that there is a case in Massachusetts, albeit unpublished. There is a case, similar type of situation where there's a potential violation where the appeals court, or at least a panel of the appeals court, said no violation because the person spoke freely. And then we have the broader argument that the defendant's never seized, and I think you agree with me there. He's always free to leave. And so when we look at the big picture here and we look at what's actually what the defendant was seeking to suppress was the identification of the outside of the car that had already been identified. And when we look at Mello's testimony, he testifies that he thought the car was gray. Somehow the police transmitted that was tan or gold, but Mello always said he thought that the car was gray. He could have seen that car on the side of the road if the police didn't impound it, if they just said, hey, you guys aren't authorized to drive, you need to keep the car on the side of the road. The police could have taken him there and he could have identified it. It was the outside of a car. The second
Without the
thing,
yellow tape around it.
correct, but he immediately sees it, he identifies it, and he's already described it the night before, and he described it as gray. That's his testimony, he describes it as gray, and the slope back was important.
Didn't he also describe, there's a difference between a max something and a...
Correct.
So we have two differences. The car is not a max, whatever a max is, and
Correct.
it's not the color that is reported.
So he testifies that the night, and we have to keep in mind, he sees it the night before, the next day the police pull it over. So there could be a difference in night and day, I'm not sure, the testimony wasn't developed there, but it's important to note that. So he says that he thinks it's a Malibu Max because of the slope back and the taillights. He goes back into his house, starts looking it up on the computer, realizes it's a simple Malibu that this car is, and prints out pictures from the internet. And
I'm not focused on him.
Mm-hmm.
I'm focused on what the cops think, because Justice Lowy points out that this may not be appropriate as an inventory, but it may be, we may have to analyze whether they have probable cause at this point, but it doesn't sound like it. It sounds like what the police are looking for is a gold max blankety blank, and they have a gray non-max blankety blank. Is that right?
I believe
I mean, this is sort of
Schaff
a brilliant hunch, but it seems like a brilliant hunch.
I think at that point, Schaff knows they're looking for a Malibu gold, and you're right, Max, that's gold or tan.
So
And-
they're looking for a gold, I mean, it's amazing that they do this, but it's a gold max Malibu, and this is a gray non-max Malibu.
So the Judge Walker credits Detective Schaff's testimony that it doesn't dawn on him until after the defendant and the occupants walk away that this could be the car. He calls Detective McDermott, and he doesn't search the car at that point.
But the question is not going to Judge Walker's finding of credibility. Assume that he credits it, and you have this color disparity. All the defendant's cases about no inventory policy, they have nothing to do with this situation at all.
Correct.
At all.
Correct.
It's about whether or not there's probable cause for the car, and if there is probable cause, whether or not you need a warrant to be able to take it back to the police station, because there's no doubt it's not an inventory in seizing the car. It's they're seizing the car because the police officer believes it's evidence from a murder.
So he's preserving it, and he was
Right.
appropriately preserving that car for later.
But he can't move it unless he has, unless there's blank, unless he has a warrant, or if he doesn't have a warrant, he has probable cause. So Justice Kaffer's questions, wait a minute, Justice Kaffer's questions are going to nothing to do with impoundment, but whether or not there's probable cause. Put the warrant aside for a moment.
So put it aside, and what we have here is a police officer who it dawned on him that this might be a car that's involved in a murder investigation, and so they impound the car to preserve it. And they were perfectly appropriately.
Hey, tell me, I mean,
No, you
it
can't
sounds,
impound for
I mean, it
investigation.
is one of the greatest guesses of all time. Why would he think that? It's not the right color, it's a different kind of Malibu.
Was
and
there
they're-
damage to it?
And it's a rental car, right?
There was damage to the underside, Your Honor.
But they couldn't see it.
So he was subject to cross-examination during the motion hearing, and that did not come out, but it was credited by the judge that it dawned on him afterwards this could be the car, so they preserved it.
It dawned on him because I took it, I hear he must have gotten a briefing in the morning or on the radio that they were looking for an Impala, is that
But
it?
it dawned on him after the occupants had left.
Why?
That testimony didn't come out during the
But give-
hearing.
help us.
But I would suggest, Your Honor, if it had dawned on him while the occupants were there, something else would have occurred.
Well, we don't know anything
We don't
about
have
the
an inevitable discovery argument in the brief, though. Every time something else would have occurred, you might be right about all of your different tributaries, but we don't have that argument.
I mean, we don't. I
But
mean,
again, we go back to the
but we
standing
just-
to
But we don't know
challenge it.
anything about the drivers we don't know anything about the shooter from the night before. We
Right.
don't know, these guys, we don't know if they're tall or small or black or
Correct.
white or,
But-
anything about
But
them.
again, the question is whether or not the defendant had standing to challenge what he's
That's
seeking
a
to
separate
suppress.
issue.
It is a separate issue. So does he even have challenge here to challenge the impoundment of the car?
I know, but we're giving you a chance to make the argument if he doesn't, because you've already made you got that argument. So now, if you lose, we want to know what you have to say about the probable cause issue. So going back to the argument that you may win, but giving you a chance if you lose it, isn't going to help on the argument we're talking about. Does the officer know about Nicholas Mello and being on the porch the night before and the curb and the scratching?
He knows about, from my understanding is he had received a briefing and he had been in the briefing that morning. He may or may not know it, that was not developed during the hearing, but I think his testimony, he was at the briefing in the morning about the murder. And I could certainly take a look at that and give a 16L on that motion hearing testimony
How
there.
far,
It confuses me a little bit, because I don't understand, did they ever call the girlfriend to let her come and
Yes.
get the car?
Yes, she came to
When?
the police station, and she admitted that she gave authority to Hanson to drive the car, and she got on the phone with Enterprise, and they told her she was in violation of her contract and canceled it. And then the police the next day went to Enterprise and received consent to search. So it wasn't searched until after that.
But when was it taken?
It was taken right after the occupants walked away. It actually was there for once it dawned on Detective Schaff that it may be the car involved in the murder or the shooting, he called Detective McDermott, who's the lead detective on the
But
case.
I guess I'm trying to, when is that in relationship to when they called the girlfriend?
The girlfriend came down, I
No, no, when they
believe,
called the girlfriend. When did they call the girlfriend?
after it was at the, I think they
After
told
it
the
was
girl.
already impounded?
I believe so.
Huh.
I believe so, it was after.
Pointless for them to call her.
Oh,
They weren't going to let her drive it away.
well, when she got to the station, they told her that she was in violation of her contract and that she wouldn't be getting the car back.
Can you address the prior bad acts issue, please?
Yes, Your Honor. The defendant makes the argument that this wasn't admissible. I think Judge Healy, during his denial of the motion for new trial, really goes through what he did at trial and during the motions in limine. He really did review the motions in limine. He listened to the arguments at trial about the admissibility of this testimony, and he really limited the scope on how the testimony could come in and for the purposes, and he limited it to identification and means to commit the crime. And we're talking about the exact same gun that was used here in a shooting that occurred 3 weeks apart in the same city. And I think Judge Healy did a very good job, and I have the findings in my brief, about limiting the testimony and even limiting how the prosecutor could elicit the information.
I know, he does it through leading questions. He says you can say there's a shooting, but not someone shot. But they're hearing about a prior shooting of the defendant. So the evidence that he had a 22 a few weeks before and shot on whatever it was, Exchange Street, 3 weeks before, is relevant on the issue of means.
In ID.
Okay, I'm going to go with both, means and ID. Okay, but means is not contested, okay? It's not contested. The issue is that he took a 22 and he shot it. When you look at the means cases, including the ones that you cited in your brief, we don't know whether or not that was the gun. We don't know.
Correct.
So the means issue that it's relevant, but it's unduly prejudicial because it's not a contested issue. The ID issue is, well, he had a 22 before and shot it, and so it must be him this time who shot it with a 22.
Actually, the testimony was, he had the 22, this particular gun.
Yeah, right, the 22, right.
So he was seen in the presence of the deuce before.
Right.
He told Grinion that he had used the deuce to shoot in the Exchange Street shooting, and he actually told...
And what does that show? That shows that it's more likely since he shot before he shot this time, right?
That shows that he could be identified as one of the shooters in this case because he shot in the Exchange Street shooting. So it goes to his identity as having...
No more than what the informant and Ortega are already talking about. They've seen him with the gun before, so they don't need the shooting because they've seen him with the gun. So they don't need the shooting. And the shooting is the same identification as he was the shooter this time. So you don't get anything more from the previous shooting other than he was the shooter last time. It's just propensity.
I would disagree, Your Honor. We have the ballistics evidence that ties in the prior shooting to this testimony, and so
So what's that show?
Same guns used.
Same guns used. There's not an issue of the gun because they've seen the gun before.
Correct.
So that shows that same ballistic evidence means he shot the person before and he
Well, we
shot
don't
him
know.
this time.
Well, we just know there was a shooting,
He
not
shot the gun before and he
shot
shot
the
it
gun
this
before.
time.
So it goes to his identity as having this particular gun before, and it goes to both, Your Honor. It would go to his identity and to the means. Was this the person who had the gun before? Yes, and he had the means to shoot Mr. Lima and kill him.
But you see, it doesn't add anything. That's what Ortega and the informant are talking about anyway, that he said he had the gun and shot it. And this is, again, the same thing.
Well, I would argue it would go to both and would be admissible in both, and I think Judge Healy did a really good job at limiting it and carefully weighing that, and it's well within his discretion to do that at trial. And so, Your Honor, if you're suggesting that it wouldn't be admissible in identity, it would be admissible on means. So it was admissible, and it was properly admitted, and it was limited.
It's relevant on both.
Correct.
At the motion to suppress hearing, did the Commonwealth offer the impoundment policy or the inventory policy of the Brockton PD?
I don't believe so, Your Honor.
So how can they show that it was done in accordance with inventory policy, which is required to justify an impoundment?
Your Honor, to be honest, my focus was on whether or not this defendant had standing to challenge the impoundment, and so I didn't really, and that was the Commonwealth's focus at the hearing, and it was our focus here on appeal. I could develop that further if Your Honor would like.
I thought you also said that the impoundment was lawful.
It was my understanding that Justice Walker had said the impoundment was lawful because it would have been it's preserving evidence of a crime, and that's what the Commonwealth was, what our position was, that Justice Walker was correct.
But that you can't Is that your position?
Your Honor, to be honest,
Impoundment can't be investigative by nature.
correct.
So are you saying that Judge Walker was wrong as to that, as a matter of law?
To be honest with you, Your Honor, I really didn't develop that in my analysis was really about whether or not he had standing to challenge. And if I could have the opportunity to go back and look at a few of those cases and to answer it more articulately in a 16-hour letter, if it would please
But
the
on
court.
the issue of standing, my understanding of the evidence is that, well, would the girlfriend have standing to challenge the impoundment if she had been in the car?
If she were, see, when we talk about the Byrd case that the defendant cites, they talk about if the driver who's in sole exclusive possession of the car, and they're also talking about possessory crimes. And the defendant was never charged with a possessory crime in relation to this car. So if the gun were in the car and it was
It's not my
recovered.
question. We're talking about the impoundment of the car. If the girlfriend was in the car as a renter, would she have standing to challenge the
I think she would.
lawfulness of the impoundment?
I think she probably would, Your Honor, but she
Okay,
was not in.
if the girlfriend says to her boyfriend, you can use my car, does the boyfriend have standing?
So that, we look to the Byrd case, and in that case, what they said was, if the person driving the car has exclusive control and is the driver and has authority from the actual renter, then he would have standing to challenge in a possessory type crime. So I don't know if that answers your question, but here, the defendant who's a passenger and unlicensed at that is not in exclusive in possession or control of the car. And so therefore, under Byrd, he doesn't have standing to challenge this.
Okay, thank you.
Your Honor, if I could just see. I just would like to address one thing that I did not raise in my brief, but it was raised in the defendant's primary brief in reply, that the Commonwealth case was strengthened by the suppression of this evidence. I just want to point out that in the opposition to the suppression of the recordings, the prosecutor was saying that the Commonwealth case would have been strengthened by the introduction of those recordings. And I think there's a confusion here. It was obviously weakened by not having those recordings. And I'd also like to point the court to the fact, and I think, Justice Lowy, you had stated this earlier, that different trial counsel had the recordings. He was there at trial. If there was a problem with any derivative evidence, and in his affidavit, he says he's aware of the statute. He's aware of the recordings, he had them. If there was anything untoward that came out at trial as derivative evidence, we would have expected him to object.
But I guess I look at it and say, why not you gave it to trial counsel, why not give it to appellate counsel?
So the judge here, Judge Healy, who was the trial judge, did not order it. And under the statute, the Commonwealth is prohibited, since it's now been found to have been illegally obtained, the Commonwealth is prohibited from disseminating it without a court order. And the trial judge said that the defendant didn't make a showing that any derivative evidence was derived from these recordings. So the Commonwealth is prohibited under the statute from providing it. And the defendant can't make a showing. Neither he can identify any.
See, this is my view, and I may be wrong about this. It's not a violation of 99C because you gave it to the defendant as you needed to, under statements of the defendant. So you did your Rule 14 automatic discovery obligation, and then the dog ate it, they lost it, and they need another copy. They don't have it.
They gave it to the defense prior to a finding that it was an illegal interception. Once it was deemed an illegal interception, the Commonwealth was prohibited from redisclosing it without a court order.
I know, and maybe that's right. My view of it is that you permissibly handed it over to the defendant, and they misplaced it, and they need another copy.
So once it was found to be an illegal interception, I think that's the problem, is we were prohibited from redisclosing it. And in addition to that, the defendant hasn't made a showing that there was any derivative evidence. And we know that because counsel had the recordings at trial and didn't object to anything.
I'm not saying you have to turn it over. I'm just saying that when the other side loses something and they need a replacement, you can turn it over without violating 99C. I'm not saying you have to.
So if this case is to be retried, Are you saying that they don't get, the new trial counsel is not going to get the transcript in the absence of a court order?
I can't answer that question at this point. I don't even know if we have the recording or a copy of it. It's,
Really?
Did you know that?
Really?
well, we may still have it, we may not still have it, I'm not sure. I haven't looked through the trial files on this. I've really focused on the record on appeal, and that was not part of this appeal. So I have not, I haven't gone outside this record, so I can't answer that question.
Okay, thank you.
Thank you, Your Honors.